Hello friends, in the series on the income tax cases, today we will discuss a very important issue. The issue is that if under the black money proceedings, if any summon has been issued by a magistrate to the accused to appear personally before him, so whether the magistrate under section 205 of the Code of Criminal Procedure 1973 has the power to dispense personal attendance of the accused. This is the issue which was before the Calcutta High Court, because the accused has approached to the High Court to dispense the personal presence of the accused before the magistrate. This issue has been taken by the Honorable Calcutta High Court in the case of Prerna Chopra versus Union of India and others, and this case has been reported in 460 ITR at page number 664, and the date of the judgment is 3rd October 2023. In the present case, in its decision, the Calcutta High Court has laid down some guidelines, or you can say rules, which should be considered by a magistrate while considering that whether an accused under the Black Money Act should be compelled to personally appear before the magistrate or not. The first rule is that the court said that it should be considered that whether the nature of the controversy is like that, whether the accused should appear before the magistrate or not. In nutshell, the nature of the controversy is important to emphasizing the personal presence of the accused before the magistrate. The second rule is that whether any useful purpose will be served by requiring the personal attendance of the accused. If no purpose will be served, or it will be just for completing the formality that the accused has to come before the magistrate, then the court said that in those circumstances, the personal presence of the accused should not be pressed. The next rule which has been laid down by the Calcutta High Court is that whether progress of trial will be hampered on account of his absence before the magistrate, meaning thereby that if it will not affect any progress of trial before the magistrate, the personal presence of the accused should not be compelled by the court. The next rule is that if the accused is making an attempt to prolong the proceedings of the trial, then in those cases the personal presence of the accused cannot be dispensed with. Or in other words, we can say that when the accused is fully cooperating with the proceedings, that it should go smoothly, or the accused is making every effort for the smooth running of the proceedings, then his personal presence should not be compelled with. The next important rule which the court laid down is that if the complaint is solely based on the documents, then in those circumstances the personal presence of the accused or the assessee under the Black Money Act should not be compelled with. Friends, although it is a case related to the Black Money Act and it is for the proceedings before the magistrate, so the question arises whether the same rules for the personal presence of the accused or the assessee under the Income Tax Act can be made applicable for the income tax proceedings. In my view, because in the income tax proceedings, generally whenever there is an allegation whether the assessee has escaped some tax or penalty or interest, all these matters are related with the documentary evidences. So the same set of rules can be applied to the income tax proceedings also, and the personal presence of the assessee before the income tax authority should not be compelled just for the sake of their personal presence is required. Because in the income tax proceedings, there are some cases where some females are there which are made the proprietor of the concern or the directors of the company, and even they are issued the notices to appear personally before the officers, in which they are not very comfortable position and they are not affecting any proceedings or outcome of the proceedings. So in those cases, the personal presence of the accused should not be pressed. At the end of this video, once again I am repeating the name of the case. The name of the case is Prerna Chopra versus Union of India and others, and this case has been reported in 460 ITR at page number 664, and the matter has been decided by Honorable Calcutta High Court, and the date of the judgment is 3rd October 2023. Thank you, friends.